Well, hello, everyone. This is John Miller. I'm the founding attorney of Rock Solid Law and Title. We've got a great subject for you this morning with an expert presenter. I am so happy to be with you today with my friend Kent Griffin, who is a family lawyer, divorce lawyer. We consider ourselves family lawyers on the estate planning side. And we do not get involved at all in the divorce process, although the divorce process does affect our estate planning practice because there are rules in place that determine what and when you can do certain things. So we're going to talk about those kind of things this morning. For those of you that might be new with us, we also practice in the areas of general business and real estate, so we can help with those kind of areas. But today we're going to focus on the estate planning, and we're going to focus particularly on the people who are going through the divorce process, about to enter the divorce process, or have just gone through the divorce process. And hopefully this will be helpful to some of our people. So good morning, Kent. Thank you so much for joining us. Would you please tell everybody a little bit about your practice?
Sure. Thank you for the introduction. Thanks for having me. Again, my name's Kent Griffin, and I am the owner and founder of Griffin Family Law. And Griffin Family Law, we practice exclusively marital and family law. So we just do family issues, with about 80% of my caseload being divorce cases or divorce-related matters. So primarily my focus is handling divorces. So I've been invited here today to speak to everybody about, I guess, the impact that a divorce may have on one's estate plan. So,
And when we're
and I can
talking
jump.
estate plan, folks, we're talking everything from a trust, a will, power of attorney, healthcare surrogate, and HIPAA release. All of those are things that have fiduciary on them. And in many instances, when we have a married couple, the spouse is the fiduciary. So what happens with respect to those things with a dissolution proceeding, Kent?
Well, I'll be happy to talk to you about that. So, there's there's two main things to look at when we're talking about an estate plan and what impact a divorce may have on that estate plan. So there's two kind of overarching concepts that controls what you can do with your estate plan. Now, number one, there are the Florida law, the probate laws in the state of Florida, which controls what you can and can't do with your will and your estate plan in general when a divorce goes into effect. But also there's something called a standing family law court order. And that's why I'm going to kind of speak in more detail about that aspect of it. So for those of you that aren't aware, when a divorce case is filed, there's a order entered by the court automatically. In the divorce case, it's called a standing family law court order. And what this order does is it lays out some general ground rules of what you can and can't do while the divorce case is pending. And it covers a lot of different things, but one of those things has an impact on your estate plan. And each county has a different standing family law court order, but generally they all say about the same thing. It's the point of them is to try to maintain the status quo. So keep things kind of status quo until the court can resolve the divorce case, whether through an agreement or through a court's order. And just to make sure that people aren't doing anything crazy with the marital assets and trying to conceal things or hide, get rid of, transfer marital assets. So that's where it comes into play. So what I was going to talk to you about is what you can and can't do while a divorce case is pending in light of that standing family law court order. And then go into a little bit about what you can do prior to the divorce being filed, before that standing family law court order is put into effect. And then what you should do once the divorce case is final and you are divorced, and then some tips on what you could potentially do with the eyes forward, looking ahead to maybe potentially getting remarried. So,
Perfect.
so I don't know if you just want me to dive right into it, John, or if you any
I
questions you
think that
specifically
sounds
want to
like
ask.
it'll fill our usual time, so I'm going to just sit back and learn myself. Folks, for any of you that are new with us, there is a chat bar kind of right here in the middle of your screen. If you have questions, if you'll just type them in there, we'll keep a few minutes at the end to make sure and get those answered. So Kent, the floor is yours, and thank you.
Okay. Well, I appreciate it, and I think everybody who's joining us here this morning to listen. I think there's going to be some information that you may have not thought about, and that you probably should. Uh, Again, going through a divorce can be very stressful and emotional time for anybody. There's a lot going on, a lot you have to think about, a lot of moving parts. And sometimes the estate plan is kind of on the back burner. So it's something that a lot of people don't really think about. However, it's actually a very important thing that needs to be thought about, of uh, what impact that divorce can have on the estate plan. So hopefully this was just kind of stress the importance of that and what you can and can't do to do it. So there are some restrictions in place about what you can do, and I'll go through those. So again, I'm first going to talk about what you can and can't do while the divorce is pending. So once a divorce case is filed, that standing family law court order is entered, what can you do? So I'm going to first start off with things that you cannot do. So you cannot change the beneficiaries on any of your major accounts. Now, there are some limited exceptions, but the general rule is once that divorce is filed, you got to keep the beneficiaries as they currently are. Again, going back to that idea of status quo. So there might be an urge to change your beneficiaries to somebody other than your soon-to-be ex-spouse. And that would make sense, but you're not allowed to do that. That's a violation of that standing family law court order. So life insurance policies, retirement accounts, typically payable on death accounts, things like that, you're not going to be able to touch, or you shouldn't touch, without risk of being found in violation of that standing family law court order. You also can't start, like I said before, you can't start transferring assets. There's again, an urge to try to maybe conceal assets or move them around to try to protect them, so to benefit you later on down the road and maybe shield them from your spouse. That's exactly what the standing family law court order is designed to prevent. So while it makes common sense to want to do that, you're going to run into trouble to do that. So you also cannot start changing titles. So you can't start changing titles of your property, of your joint accounts, things like that. You can't start taking the other spouse off of any joint accounts. You can't transfer title of the property or deeds out of your spouse's name. You got to leave all that alone. So basically, the court doesn't want you taking matters into your own hands and deciding what to do with your property, because in the eyes of the court, most of it is not your property. It's considered marital property. So your spouse has a say. So you really need to leave all that stuff alone. So then you may ask, well, it sounds like I can't really do a whole lot. If I can't change beneficiaries, if I can't move around assets, if I can't change titles, then what can I do? And that's a good question, but there are things that you can do and that you should do. Number one, you should update your healthcare surrogate, powers of attorneys, living will. So these are the documents that you execute to give somebody else authority to act on your behalf in the event of certain situations. Power of attorney can be any situation. You can give that authority immediately to somebody, or you can give authority to somebody in the event of incapacity. Whereas the healthcare surrogate, living wills, those are more spring into action once you're incapacitated. You have somebody acting on your behalf and making decisions, medical decisions, things like that, end of life treatment decisions. What basically when are you going to allow somebody to pull the plug on you, and all that kind of fun stuff. Most people aren't going to want your soon-to-be ex-spouse, who you're in the middle of a divorce with, making those types of decisions for you and when to pull the plug. So you're going to want to update those documents, and you're allowed to update those documents. It's also important to know that in Florida, under Florida law, once the divorce case is filed, those documents are automatically revoked. So if you have a power of attorney that gives your spouse the right to make certain decisions, healthcare surrogate, same thing, those things are automatically revoked by the filing of the divorce. So you may say, well, if they're automatically revoked, then I don't really need to do anything. But the revocation is not sufficient. So that just means that that person can no longer act on your behalf. You then have to replace those documents that give somebody the power to do those things. So without that, you're not going to have anybody to make those decisions. So you have to redo those documents, appoint somebody that you trust to do those things who's not your spouse. And again, you're allowed to do that at any point in time, regardless of whether the divorce is finalized or pending. And not only are you allowed to do those things, you should, because again, you don't want your spouse making those decisions. Also, even though there's an automatic revocation once the divorce is filed, sometimes people try to use documents that have been revoked. There's no uniform thing that all points bulletin that gets sent out to every hospital, every bank, that these things have been revoked. So you need to make sure that these documents are amended, updated, and then sent out to the relevant places so that they are aware of it. So it's hard for these banks and financial institutions and hospitals to know if a power of attorney is active or has been revoked. So it's a good idea just to do that. The second thing is that while there are restrictions, you are allowed to update your will and your estate plan, specifically your will, when the divorce is pending. So once the divorce is filed, some people believe because of the standing family law court order that you are not allowed to update your will. That is not correct. You are allowed to update your will. There's just restrictions on what you can. So you cannot redo everything because it might be contrary to that standing family law court order. However, you should at least update the will to update a new personal representative, the executor. Again, you don't want your soon-to-be ex-spouse to be in charge of your estate in the probate action. Should you pass away during the divorce process, you probably want somebody else that's going to have is going to be more aligned with your interest. And typically, your soon-to-be ex-spouse is not going to be aligned with the same interests you are. So, at a minimum, you can do that. You can update your guardians if you have minor children. A lot of people put in their wills guardian language for the children, who's going to take care of them in the event certain events happen. Again, you may not want your former spouse to be the guardian. Now, that being said, that's a little tricky because they're going to have priority. But if something happens to both of you, you want to have somebody else update that part of it. So those are the things that you can do and you should do to your will. There's nothing stopping you from updating your entire will. Just so people know, you can update your entire will and you can send everything to somebody else other than your soon-to-be ex-spouse. There's nothing stopping you from doing that. So you can do that. The issue with that is the other overarching concept that I talked about. Florida probate law is going to step in if you give everything to somebody else other than your spouse and you're still married. In the event that you die, she or he, whoever the surviving spouse is, has some protections from Florida law that will kick in. They can claim their elective share. They can claim their homestead rights. So it's the concept of disinheriting your spouse. So Florida law protects somebody from disinheriting their spouse, which means giving everything away to somebody other than their spouse. So Florida law will step in and say, hold up, that's not fair. You can't do that. They're entitled to something. So that being said, the elective share is only 30%. Or roughly 30%. It depends on the circumstance of the case. But roughly 30% of your estate is what the other spouse can claim. So 30% is still less than 100%. So you can still update everything if you want. I just suggest you speak with an attorney about your specific circumstances, whether it be an estate planning attorney or your divorce attorney, or typically a combination of both. You want to speak with both of them and see what's best for your particular plan and your particular situation. But you're restricted is what you need to know. You can update everything. There are restrictions in place, and Florida law will kick in. So now, if you don't update those things, again, once the divorce is finalized, there are other Florida law still kicks in and says, all right, well, you didn't update your plan, but you're divorced now. They're not going to send everything to your ex-spouse. So again, there are protections of Florida law will kick in and say, all right, well, even though you didn't update your plan, we're not going to send everything to your ex-spouse because that doesn't make any sense. So Florida law says once the divorce is finalized, basically any language giving any property to your ex-spouse is revoked. But again, revocation is only you're only halfway there. They're not going to the Florida law is not going to rewrite your will to say who it should go to. So then you're going to be left with what the state says should happen with your property, which is not always going to be in line with what you want. So just keep in mind that you need to update these things so that things go how you want and not how the state wants. So
Can't, may I
that's
interject? I would
well,
say that if you don't update them during the process, and I could see why you might not, because the assets are subject to the dissolution action. Certainly after the final order, absolutely the last will and testament, trust, if anything's left in a trust, or maybe a case for a new trust, power of attorney, healthcare surrogate, those should be updated, even if you've named secondary fiduciaries, to go ahead and take your ex-spouse out of there. Because yes, I agree with you, Kent, that Florida law will control, but why would you want to give that ex-spouse any platform to have standing to intervene in your probate with your family after you're gone? One of the things we're about is protecting legacy. And if you tee up that ex-spouse to have a standing to make an argument in the probate matter, your family's going to talk about you for 100 years, not in good terms. So that I agree with you completely, that if not during, those ought to be treated as soon after that dissolution order is final as possible.
I agree completely. And I guess that's one more thing about what you can do with your will. And again, this is something that's going to be specific to the particular county in which you're filed for divorce, the specific language of the standing family law court order, because there are some differences county to county. For example, Duval counties is a little bit different than St. Johns County, but general idea, but there are some differences. So, but you might have more freedom to do something in one county versus another. But you are able to potentially update your will for things that are clearly non-marital property. So if you have things that maybe there's a prenuptial agreement in place that identifies what your separate property is versus marital property, you have a little more freedom when it comes to non-marital property if it's clearly identified. So those things, even though it's non-marital, if you're in a happy marriage, you may be leaving those things for your spouse, but now you've got the divorce coming, you no longer want to do that. Those things can be updated in the will and just kind of don't touch the marital property. So now that you can still run into some issues with that because, for example, in Duval County, they don't want you messing around with anything that's could be considered marital or non-marital because they don't want the parties in the divorce making a determination of what they think is non-marital because what a certain party believes is non-marital uh, might not be consistent with what the law says. Everyone thinks what they have is non-marital. But that is something that if you do it properly, that you can protect that property and you can update those things. Now, John brings up a good point that you should do these things, but if you don't during the divorce, you absolutely need to do it once the divorce is filed or completed, rather. Um, One point to that is that if you do update your will during the process, just know that you're going to have to update it again once the divorce is finalized. So people that have the foresight and actually think about their estate plan during the divorce, that's great. But sometimes they update it and they think they've kind of done their job there. But just know that the finalization of the divorce is a triggering event that changes everything. So you got to update it again once the divorce is finalized. But if you've done all the legwork, it might not be that much work to update it. It might just be a few updates here and there, just removing all language regarding your former spouse. It might not take as much work, but you absolutely will need to update that once the divorce is finalized, or you're going to be in the same situation. You're going to have language that's not going to be applicable, and if that language is revoked, then it's going to be left to the state to decide what to do with your stuff. And that's what we're trying to avoid here. We want your stuff to go as you wish and not as the state decides. Um,
And I
So
think I'm just envisioning, obviously every fact scenario will be different. And that's why we lawyers have to talk to you and find out what your scenario is with the individual. But I can envision a codicil during the divorce that would take care of those things that could be taken care of. And then revoking that will fully and doing a whole new one after the finalization of the process as probably a beginning point for the best strategy.
I think that makes perfect sense. I'm going to touch base briefly on. So I spent a lot of time talking about this standing family law court order, what restrictions that has on what your ability to update your plan is. So it'd be reasonable to ask, well, why can't I just do these things prior to the divorce being filed? Because this standing family law court order is not triggered or does not go into effect until the divorce is filed. So that's a very good question. And the answer is yes, you do have more freedom to update your estate plan prior to the divorce being filed. So you don't have the restrictions of the standing family law court order. So that means you can, with some exceptions, you can update your beneficiaries. You can change titles, things. You can move property. There's nothing restricting you from doing that. So that if you know a divorce is coming down the pipeline, that is something that you should talk to an estate planning attorney, talk to a divorce attorney about, and see what your options are in your specific circumstances. The one thing to keep in mind, though, is although you may not be violating the standing family law court order because it's not in effect yet, that does not mean that there are not any potential repercussions to anything that you do. So if you do things, if you make substantial changes to your estate plan prior to a divorce being filed, the other side is most likely going to make the argument that you are dissipating marital assets and you're doing these things in bad faith to try to shield part of the estate from going to the other spouse. Uh, and even if that's not true, which it very well could be true, but even if not, it's going to cause additional litigation in the divorce. You're going to have to defend yourself in court of why you did these things and why you weren't doing these with the intent to take them away from your spouse. And it's going to prolong the litigation and expenses most likely. So you have to keep that in mind. So and again, that's why you shouldn't do that without the help of a lawyer who can tell you, make sure that you're doing it the right way. One also thing is there are certain beneficiaries, for example, like a 401k, that's a federal or ERISA type account. Even if you're married, even if the divorce hasn't been filed yet, you cannot change that beneficiary of that account to somebody other than their spouse unless your spouse explicitly consents in writing. So there are certain things you can't do even without the standing family law court order. But again, but it does make sense to make some updates if you know the divorce is coming down the pipeline. I guess counter to that is if you think divorce is coming, you update everything and then you reconcile and get back together, everything's fine. Just know that you're gonna have to update your will again because you've changed everything. Uh, so that's kind of, I guess, what you can do before you do have more freedom. You also still have to think about if you know the divorce is coming, hasn't been filed yet, and you change everything so it goes to somebody else, your mistress maybe. Just know that the Florida law, probate laws, and step into about disinheriting your spouse, things like that. So that's something else to keep in mind. Um, I'm going to touch base a little bit, unless John has anything to add to any of that. I'm going to touch base a little bit or revisit, I guess, what you should do once the divorce is finalized. I think John's already hit it. Basically, once the divorce is finalized, you should update everything. If you didn't do it during the divorce, if you didn't do it prior to the divorce, now's the time that you have to do it. And you have to update your will, if you have a trust, your medical directives, healthcare surrogate, powers of attorney. Make sure that all that's updated to remove anything that could be residual to your ex-spouse. And the only caveat there is you have to do that consistent with the final judgment of the divorce. So there may be certain restrictions in place once you get divorced of what you can and can't do. For example, for beneficiaries, it's very common that in a divorce, especially if there's children involved, that you may be required to maintain certain life insurance policies with your ex-spouse as the beneficiary, or maybe your children. So those things have to be updated consistent with what that final judgment of the dissolution of marriage says. Because if you update all those beneficiaries, you can be found in contempt for not following that order. So, but yeah, update all the beneficiaries you can. That is not prevented by the final judgment. Change all the titles. So if you got a house, make sure you update the deed. Quitclaim deeds are necessary to transfer the title from one spouse to another. Update the titles of your vehicles. Your all the thing, all of it. And John will be happy to talk to you about those things in the event that happens and what actually needs to be done. Do you have anything to add as far as that goes, John, about what needs to be done once the divorce is finalized?
No, I think that's completely appropriate. It's surprising to me how few people we actually see, knowing that the instance of divorce out there. I just don't think folks think about it, and maybe we need to do a better job of reminding them that that's a really important thing to update. So good thing to get that on our radar.
I agree. And to kind of wrap things up, I'll just give you kind of a couple tips about, all right, so now you've divorced, you've updated your estate plan, you've done everything, you attended our webinar this morning and you did everything that you're supposed to do. But now you're thinking about giving marriage another shot. So in that situation, it's recommended or typically recommended that to protect yourself in the event of a second marriage, you may want to look into a prenuptial agreement, basically. Things are a little different for a second time or third time or fourth time around in a marriage, because a lot of times you have existing family that you're going to want to protect in the event that you pass away, but you have to balance that with the interest of your current spouse. So you kind of want to make sure that they're all protected. And if you don't do a prenuptial agreement, or you don't kind of identify your separate property, your marital property, what property should go to your existing family, your current kids, what property should go to your spouse, then most of that is going to kind of default to your spouse. So a lot of times, if somebody doesn't have a prenuptial agreement or doesn't update their estate plan for the second marriage, then their existing children, things like that, are going to be left out of it a lot of times. A lot of it defaults to the current spouse. So that's just something to keep an eye on. And it's just always a good idea if you have there's the bigger chance that you have other separate property in the second marriage, because you might have property from your first marriage. So it's always a good idea to identify what your separate property is, and then what property is going to be considered marital for your second marriage. And then there you can keep your separate property in the event of a divorce, and everything goes as you want there, and then you can share whatever you have marital. So it's just something to keep an eye on if you do intend to get remarried, to look into a prenuptial agreement.
And prenuptial is significantly easier to get in place than postnuptial. So it's a hard conversation. I understand that. But for mature people who understand that life happens, a prenup certainly is a great tool. And then also, we will, if we do subsequent estate planning, a trust, wills, we're going to make those consistent with the prenuptial agreement. So there's already a little bit of a playbook in place for drafting of those things as well. So very, very good, not advice, but suggestions, knowledge, Kent, for everybody that's
Right.
on. I have to think that I'm not the only one on the call who's curious. What happens when somebody violates that standing order?
Well, it's subject to contempt. So if somebody violates that order, the other side will file a motion for contempt, and then there'll be a hearing on it. And if the court agrees that you violated that provision, you can be found in contempt. Now, being found in contempt has a lot of different potential consequences to it. Contempt means that you can potentially be incarcerated for not for violating that provision. Now, that's the extreme point, but a lot of it is more relevant to this discussion this morning. Is the court has the power to claw back whatever you've done, and you'd have to provide an accounting, and you might have to reimburse or compensate the other side for everything you've done. So basically the court can undo what you did to try to protect yourself, and then assess you attorney's fees for all the costs that it caused by you doing it. So it can be there's a wide spectrum what can happen, but it's not good either way you look at it, and it's going to at a minimum it's going to cost time and money.
Sure. Extra expense. And I would guess, and I don't even pretend to know a lot about your area of law, but that if a party had done a lot is caught having moving a lot of assets, prior to the action being filed, that the courts wouldn't usually take very kindly to that. Would I be on the right track?
That's correct. You're ultimately, if you can't figure out your issues on your own through a settlement, you're going to end up in front of a judge. So if the judge knows that you were acting in bad faith prior to the divorce being filed, that typically is not going to go well for you when it comes to the judge making a ruling on all the issues relevant to your life. So
Yeah.
it's not typically the way you want to start off the divorce process.
Yeah, it's been a long, long time since I litigated, Kent, but judges are human too, and they size up people. And I always found one of the biggest things is to not immediately turn the judge against you by having done something that really didn't have a great chance of succeeding in the first place, and put you in bad favor in front of the court. So wow. Well, I certainly learned stuff this morning. I know we went a few minutes over, but this is great information, Kent. And I sincerely appreciate you taking time out of what I know is your busy schedule to join us this morning. Folks, if you know somebody who needs help in the divorce dissolution area, Kent's right out here at the beach, and you can find him at what's your website, Kent?
GriffinFamilyLaw.com.
There you go. Just look him right up. And of course, if you got here through us and know us and need that information, we're happy to give it to you. If there's any help on the estate planning side, before, during, or after, or just for some consultation and advice, we are, of course, available here at Rock Solid Law to help you with that. Kent, this has been very informative. I really, really appreciate that you took your time to be with us today. Thank you. Sincerely, thank you.
Well, my pleasure. Thanks for having me.
All right, guys, I'm going to give you the Commodores for just another minute and turn you back loose into the world. For those of you that joined us online or have watched the video later, feel free to contact either one of us as you need. Again, I'm John Miller, senior attorney at Rock Solid Law and Title. Wait. It's a thank you. You're very, very welcome. I thought there was a last minute question coming through. Everybody, take care. We'll see you soon. Kent,
Have a great day. Thank you.
All right. Bye-bye.